Today we need to talk about the Supreme Court's decision in the Dobbs abortion case. We in the Second Amendment community need to understand this because often the anti-gun community tries to undercut and discredit the same United States Supreme Court that gave us the Nysurpa versus Bruin big win in the Second Amendment space. And the anti-gunners try to discredit that decision by attacking the U.S. Supreme Court for screwing up or getting wrong the Dobbs decision in the context of the so-called right to an abortion. You need to understand how to discuss this abortion decision so you can defend the Bruin decision and the Supreme Court decisions in this space. I'll teach you how in just one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so, and feel free to share these videos far and wide while you like them. We talk mostly about the Second Amendment, but because the Dobbs abortion decision that was just decided is such a big part of the discussion today, I want to walk you through how to think about the Dobbs abortion case and Roe v. Wade and Casey, the abortion cases, so you understand how to explain why they're entirely consistent, meaning what just happened in the Dobbs case, with the Bruin decisions and the other Supreme Court decisions, because the anti-gunners are trying to undercut our Second Amendment precedents by saying that the Supreme Court is rogue and politicized and all this sort of thing, and they point to the abortion cases, or specifically the abortion case of Dobbs, to demonstrate this point. So I want you to be the smartest person in the room, so I'm going to tell you and teach you how to think about the Second Amendment cases in contrast with the so-called abortion cases so you understand how they work together. Okay, here we go. To begin with, the reason why the United States Supreme Court protects the right to keep and bear arms and no longer protects the alleged right, which is no longer a right according to the Supreme Court, the alleged right to an abortion, is first and foremost quite simple. You see, the words, the right of the people to keep and bear arms is actually in the United States Constitution. It's in the Second Amendment, which was ratified in 1791 by our founding fathers. So you have the right to keep and bear arms is actually in the text of the Constitution and the Bill of Rights. In contrast, if you ask your liberal friends or people that argue about abortion, where does the word abortion appear in the text of the Constitution or the text of the Bill of Rights? They will obviously not find it because the right to an abortion, the word abortion, appears nowhere in the constitutional document. It doesn't appear in the Bill of Rights that was adopted in the late 18th century by our founding fathers. So that's the first thing to keep in mind if anybody mentions abortion. One is actually in the text of the Constitution, the other is not. Number one. Number two, American history. Now, here is something I want you to step back briefly, because this is important to understand, and we're going to talk about this more in the context of the Second Amendment in other videos, because it's very important for you to understand. Step back for a moment. There are arguments that you have two critical constitutional moments in American history. There's, of course, many, but I think there's two key ones I want you to really understand. The first one, of course, is the creation of the United States Constitution and the creation of the Second Amendment of the Bill of Rights, which, of course, takes place in the late 18th century, right, the 1700s, specifically 1791, which is the Second Amendment and the Bill of Rights is ratified by the first Congress and the Americans. Okay, that's the key year, 1791. But it's not the only year I want you to understand. There's another year that I want you to really kind of memorize. I don't ask you to memorize that much, but I ask you to memorize 1791, the year the Second Amendment was ratified, and now I want you to remember a second date, okay? That is the year 1868. 1868. Now, why am I asking you to remember the year 1868 to understand the Second Amendment right to keep and bear arms as well as the abortion debates? You see, we had in the United States a civil war that took place essentially from 1861 to 1865, okay? That was that 5-year period right around there. That was 1861, 1865 to the Civil War. The North prevails, the South, the slave-based South fails and loses the war. And now you have a new America in a sense. So what does the new America mean? Well, obviously the biggest difference is that the African Americans that were enslaved in the South were now free men. Free men, okay? And that's important because you have things like the Freedmen's Bureau created to have the former slaves brought into the American polity, to bring them into society, to give them their civil rights. And of course, one of the critical civil rights that the North works hard to make sure the freed slaves have is the right to keep and bear arms and firearms. And in the Bruin case, as you know from this channel, Clarence Thomas actually discusses how the freed slaves used their former army rifles and muskets to defend themselves after the Civil War ended. Okay, so the Civil War ends in 1865. So 1868 is the year, again, 1791, the Second Amendment is ratified. 1868 is the other year. Why am I talking about 1868, 3 years after the Civil War ends? You see, it's because 1868 is when you have 3 constitutional amendments, critically important ones: the 13th, the 14th, and the 15th Amendments. We're going to focus on the 14th Amendment here, but as a reminder, the 13th Amendment freed the slaves. It was the constitutional amendment says there's no more involuntary servitude or slavery in the United States. It's over. That's the 13th Amendment to the United States Constitution. The 15th Amendment, we'll get back to the 14th in a second, but the 15th Amendment says that the freed African American slaves now have the right to vote. But the 14th Amendment is key to understanding the Second Amendment to some degree, but most importantly, the question about abortion. You see, in 1868, the 14th Amendment was enacted, and the 14th Amendment basically says that all the civil rights associated with being an American are now going to be bestowed upon the freed African Americans in the South. Again, the 13th Amendment eliminates slavery. The 14th Amendment says that everyone in America, including the freed slaves, shall have equal protection of law, due process of law. They have all the rights, basically, of an American going forward. And the 15th Amendment says the freed slaves have the right to vote. Okay. Now, why am I teaching you this? It's very important because until 1868 and the enactment of the 14th Amendment, the 14th Amendment is the key one for our purposes. Until you have the 14th Amendment, the initial Bill of Rights, the first 10 amendments to the Constitution, the Bill of Rights, including the Second Amendment, only legally applied to the federal government, meaning the Bill of Rights was initially designed to be a restriction on the power of the federal government to infringe upon or violate or restrict Americans' constitutional rights. So the first 10 amendments in 1791 are designed about restricting the federal government as to violating our rights. It didn't specifically deal with state governments or local governments being able to take away our rights. So what changes? In 1868, the focus becomes we no longer are going to allow states or localities to take away our rights. Just like the federal government's not allowed to take away our rights as of 1791, now in 1868, and by the way, I'm keeping this history general. We don't need to get into all the detailed history, how this mechanically occurred over time. It's not necessary to understand this. What you need to just understand is that in 1868, the 13th, 14th, and 15th Amendment get enacted and ratified, and as part of that, all Americans, including the freed African American slaves, are now supposed to have equal civil rights and equal constitutional rights and the like. And again, the idea of 1868's 14th Amendment was that all those restrictions on the federal government enacted in the Bill of Rights in 1791 would now apply to the state and to the local governments. Again, there's some mechanical details we could talk about in a subsequent segment about incorporation and things like this, but this is not the purpose of this. Okay, now why am I telling you this? Why do you need to know to understand abortion questions, the difference between 1791 and 1868, and to some degree, why do you need to understand this for the purpose of the Second Amendment? I'll tell you why. Because When Roe v. Wade, and we all know Roe v. Wade, in 1973, the Supreme Court decided a case called Roe v. Wade. And in Roe v. Wade, they said that there is a right to an abortion. A woman has a right to an abortion, basically in the first trimester, meaning the first 3 months of the pregnancy. They kind of became squishy after that. But the bottom line is in Roe v. Wade, they said no law in America can restrict the right to abortion, essentially in the first 3 months of a pregnancy. That's basically what it said. Now, why does this matter? Because what law did Roe v. Wade rely upon to find in the Constitution a right to an abortion, where we know the word abortion does not appear in the constitutional text, and the word abortion does not appear in the Bill of Rights? So how did that Supreme Court in 1973 decide Roe v. Wade, saying that women have a right to abort a fetus, a baby, right, in the first 90 days of a pregnancy, no matter what anyone says, and no state, federal, or any other government can interfere with that? The answer is that the Roe v. Wade Supreme Court relied upon the 14th Amendment. The 14th Amendment that was ratified in 1868 to say that in the 14th Amendment, the right to an abortion can be found in the penumbras and emanations and implications of the language in the 14th Amendment. Specifically, the due process clause, which they called substantive due process, a little oxymoronic there, but again, don't need to get into those weeds on this. All you need to know that in 1868, the 14th Amendment is enacted, and Roe v. Wade's Supreme Court used that 1868 14th Amendment to find a right to an abortion in the United States Constitution, even though the word abortion is never found in the text. So from 1973 until 2022, you have this ongoing fight over the right to an abortion, with the pro-life saying that the fetus, the baby, is a baby. It's an unborn baby with its own unique DNA. And I'll try to make the pro-life argument real quick right here, though, this is not about pro-life or pro-choice. I'm trying to give you legal understanding of the thing. But the pro-life argument is basically like when you have conception, you have a living being that has its own unique DNA, separate from the mother, separate from the father. And because it has its own unique DNA, it's a life that's supposed to be protected and should be protected under the law. Okay? That's kind of the gist of it. And I think the added point they would make is a point Ronald Reagan made as president. Ronald Reagan said he was pro-life. And why was he pro-life? He says, if you're walking through the woods and you come across a body lying in the middle of the path, and you don't know if it's alive and you don't know if it's dead, you presume it's alive. You don't assume it's dead. So Reagan's view, of course, was that if there's any questions about whether or not the fetus is alive or dead, we should presume it's alive because the alternative is kind of terrible. That was the Reagan position on abortion. Again, this is not a political statement. I'm trying to give you the law of this. Okay, so from 1973 until 2022, you have this battle over the right to abortion. So in 2022, a month or so ago, the United States Supreme Court decided the Dobbs case, a case that came out of the state of Mississippi that had restrictions on when you could ban abortion. It was challenged all the way up, and the Supreme Court upheld those laws and said that Roe v. Wade was no longer the law of the land because it was wrongly decided. Okay, that's the bottom line. They also made reference to a case called Casey, because Casey, I think, in the 1990s upheld Roe v. Wade and kind of an interesting decision. I won't need to get into it here, but basically the Supreme Court said that Casey's no longer good law, Roe's no longer good law, the right to an abortion is no longer the law of the land under the Constitution. You go back and fight it out with the states. Again, the Supreme Court did not say that abortion is right or wrong. They simply said that we, the Supreme Court, never should have got in the business of determining whether or not there is a constitutional right to an abortion or if abortion's good or bad. Why? Because this is not our job. Institutionally, the job of determining abortion policy is with the states and local governments. That's essentially what they said. They washed their hands of it and said, hey, not our problem. You go fight it out with the state legislatures. You do your thing down there in the political process. Don't mess with us. This is not a legal question. This is a public policy question. You figure it out in the states. So that's what the Supreme Court said in Dobbs. Now, and the Supreme Court's rationale in Dobbs was that abortion is not in the text of the Constitution, and the concept of abortion or abortion rights is not deeply rooted in American history. It's not something that's essential for ordered liberty. And they focused on the time period around 1868. Now, again, you're saying, Mark, why do we talk about 1868 in the context of abortion again? It's because the Roe v. Wade decision used the 14th Amendment enacted in 1868 as the basis for deciding the Roe v. Wade case. They did not use the Bill of Rights in 1791 because there was no way at all that you could use the original Bill of Rights to find a right to an abortion. So the only way you could find a right to an abortion, if anywhere, was in the 14th Amendment enacted in 1868. So this is important because you will sometimes see in op-eds and discussions and attacks on the internet the following argument. They will say, well, Justice Alito played games with history because if you look at the founding of our country, the founding fathers that they loved so much with the Second Amendment in 1791, he doesn't even talk about the right to an abortion in 1791. No, he really doesn't. Now, you know why? Because the legal argument in favor of a constitutional right for abortion is not really based in 1791. It's based in what the 14th Amendment meant in 1868. So the reason why the Supreme Court did not laser focus and spend a lot of time on the year 1791 like they do in Second Amendment cases is because the right to an abortion, the alleged right to an abortion in Roe v. Wade, arose from the 14th Amendment enacted not in 1791, but in 1868. And that's why Alito's focus in his opinion was on the 1868, the late 19th century American history to try to understand what the founding fathers of the 14th Amendment were thinking when they enacted the 14th Amendment, as opposed to what the founding fathers of the Second Amendment and the first 10 amendments were thinking, because it was a different set of laws and a different set of people. And therefore, Alito focused on 1868's laws in America to figure out if abortion was a fundamental, deeply rooted right or not, as opposed to 1791. So that's a very important distinction for you to have. And the last point I want to make, I hope this is clear as to why the Second Amendment, which is in the text, is protected and the right to an abortion, the alleged right to an abortion, is not protected. I hope this is making sense to you. And my last point is this, and you will be the smartest person in the room if you make this point, which it goes like this. The abortion question has two sides to it. And what I mean by that is you have the right to life side, which says that as soon as you have conception, or something along those lines, it is a human life entitled to protections from the law. And then you have the pro-choice side that basically says that that is not true, at least for much of the early stages of pregnancy, and maybe some people change in the second and third trimester. But in the first 90 days, generally speaking, the pro-choice view, that is like it's up to the mother, up to the woman, okay? Here's the thing. So Roe v. Wade took the question of abortion away from the American people and decided it in favor of the pro-choice movement. They said that the right to an abortion is a constitutional right, even though it's not in the text of the Constitution. We find it as such. We are solving this political problem for Americans. We're just deciding it right now. No political debate. We, the Supreme Court, unelected judges in D.C., have decided the question of abortion. Game over. Okay? Now, they have in Dobbs said, not our business. We're getting rid of Roe v. Wade. You fight it out. Whatever you decide, you decide. We're not deciding the abortion question. But there's another argument, a constitutional argument, that would be, I would say, the legitimate counterparty, the counter-argument to the Roe v. Wade decision. And it goes something like this. The argument is that under the 14th Amendment, you have the right to life and liberty. And that cannot be taken away from you without due process of law. Likewise, in the Eighth Amendment, which is you cannot be put to death, right? You cannot be put to death without due process, and you cannot be put to death in a cruel and unusual way. That's what the Eighth Amendment says. The Eighth Amendment has been incorporated and applied to the states through the 14th Amendment. So again, if you want the extreme pro-life argument, in other words, if you want the pro-life argument that would be the equivalent of Roe v. Wade for the pro-life movement, then the Supreme Court would not have done what they did in Dobbs. They would have actually found that the fetus, the unborn baby, was an American citizen, was an actual human being and an American citizen entitled to all the protections of law that we have, and that to terminate the life of an American citizen would violate the Fifth Amendment's right to life. You cannot lose your life or liberty without due process of law. They could say that, and then they could take it to the next level and say under the Eighth Amendment, you cannot be put to death in a cruel and unusual way. Again, another affirmation that you have a right to life. And they could have said an unborn child, an unborn fetus, is in fact a human life entitled to these protections, and laws allowing for abortion may not be constitutional or are not constitutional. That would be the equivalent of Roe v. Wade for the pro-life movement. But the Supreme Court did none of this. The Supreme Court said, no, we're not deciding either of this stuff. All we're deciding is this: we, the Supreme Court, are not supposed to be involved because there's nothing in the law that makes us interpret the Constitution to find a right to an abortion. Unlike the right to keep and bear arms, which is in the text of the Constitution and is based in American history at the time of the founding and beyond, the so-called right to abortion is completely different than that because, again, it's not in the text and there's no deeply rooted foundation or deeply rooted notion that there is a right to abortion in American life. Okay, to wrap up, I hope you learned a little bit something here today, but I think it's very important for you to understand how to explain why the Second Amendment's right to keep and bear arms is protected, why the so-called right to an abortion is not protected, and why the Supreme Court sent it back to the states to debate it out, but they don't send questions about gun control back to the states to debate it out because you have a fundamental right to keep and bear arms. There is no text or anything like that implying that you have a fundamental right to an abortion. It's just not there, nor is it there in our American history. In 1868, when they adopted the 14th Amendment, from which Roe v. Wade said the right to an abortion presumably arose, and the Supreme Court in Dobbs said, yeah, there's no basis in history or fact or anything to conclude that. Back to the states, let the states fight it out. We're out of the abortion business going forward. Okay, hope you learned something here today. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.